of the ICDR to the 17th edition of our annual ICDR Practice Moot and Lecture Series. I am Rafael Carmona. I'm part of the team that organizes this Practice Moot, and I want to emphasize that I'm just a very small part of the team. I want to give a lot of credit to my colleague, Elizabeth Robertson, who's handling now the virtual part of the Practice Moot, and to my colleague also, Shakira Safel, and they've worked so hard to organize this, and we're very grateful for their work. And I want to thank also all the arbitrators that devote their time to help with this educational project and hopefully to help you improve your skills and practice for when you go to Vienna. I want to also take a moment of your time to say from the ICDR, this is an initiative that we find very valuable. We've been from almost the very beginning sponsors of the Peace Moot. This is, as you know, the 17th edition of our Practice Moot. And we also have other initiatives going on in Vienna. In particular, I will mention that we will organize the 18th edition of our ICDR Y&I Coffee House debate. It's a very fun debate moderated by Mark Cantor and Patricia Shaughnessy, who, as Greta knows, they will do their best to make the life of our debaters miserable. So it will be very fun. It will be a very elegant palais there in Vienna, as these events happen to be. And so I encourage you to go register for that. And I also encourage you to register to ICDR Y&I, ICDR Young and International. It's our young practitioners group. I am very involved with it. And we organize events like that one, a lot of webinars also. And we try and make it all very educational and fun, and try to promote arbitration and make it useful to young practitioners. Also, I will mention, just to emphasize our support to the Peace Moot, Bridget McCormack, our CEO and president, will be there in Vienna. She's going to give some welcome remarks. So again, these educational initiatives are something that we take very seriously. We also have some initiatives to support diverse students, such as the Higginbotham Fellows and the ADR diversity scholarships from the AAA ICDR Foundation that you can look up online. And again, I also encourage you to join our ICDR Young and International group. And in that regard, if you look for ICDR Young and International in our website, you will find registration forms in English and in Spanish. And if you complete them and send it to us, we will add it to the distribution list. We also have a LinkedIn group, ICDR Young and International, where you can join. With that, and without further ado, you haven't come here to hear me talk, so let me introduce Gretta Walter very briefly, although she needs no introduction. She is a partner at Chaffetz Lindsay. She is a graduate at American University and as an LLM also from Stockholm University. She has a broad range of experience under all the roles of the AAA, international, commercial, construction, even employment. She has experience also with a broad range of industries. I'll just mention a few because otherwise we're going to be here for a while. Construction, infrastructure projects, energy projects, licensing and distribution agreements, investment agreements, banking and finance, you name it. I will simply add also, Greta was in fact part of our ICDR Y&I board for many years. So I can attest, she was working with me for many years. She's not only a brilliant lawyer, she's also a very patient one who had to deal with me and all of our issues.
I would say the opposite was true, probably.
So without further ado, Greta, I give you the floor and thank you very much.
Thank you very much for that very nice introduction, Rafa. It's I would maybe just before I get in echo what Rafael was saying regarding ICDR Y&I. It's really a phenomenal organization. It's free to join. Most of the events that the organization puts on are free. I found it really a great way to learn about issues in arbitration, meet with peers in other jurisdictions, kind of a continuation of what this is. So if you are interested in this field, sign up for it. It's really a good opportunity to see what's going on out there, and also a great opportunity for an early leadership position in your career as well. So look into it. It's well worth it in the end. So let me get my slides going here for a second. Okay, I think we're good to go. So other than thanking Raphael for the nice introduction, I'll also thank Raphael and the ICDR for inviting me to be here today. It's a bit of a kind of surreal moment, to be honest with you, that I was invited to speak as the keynote at the pre-Moot today. And the reason for that is because 14 years ago, so at the third edition of the ICDR pre-Moot, I was a law school student myself competing in the BIS, and I was up in New York to participate in ICDR's practice Moot. As the case is today, this pre-Moot was, as it is now, a very prestigious and high quality pre-Moot with great arbitrators. And also, as it is today, teams had to apply to get into it. Now, for the second edition, my team applied. I was based in Washington, DC, and we did not get accepted to participate. However, in my last year, we were accepted to participate for the third edition, and very excited we got to go up to New York for the weekend to come practice our arguments. It was exciting as a third-year law student to come to New York, as maybe some of you are here for it. We stayed in a ridiculously cheap hotel in Times Square, ate ridiculously terrible pizza. As a proper New Yorker now, I know that's embarrassing. You would never want to stay in Times Square or eat that pizza, but it was amazing at the time. And then, as many of you, we came to the ICDR's offices right here, the same location, to practice our arguments on the Friday before the weekend. So, with my coaches and teammates, we were ready to go and try out our arguments and our cases before the arbitrators. Now, I was part of the team arguing on the merits of the case. My teammate was arguing the procedural issues. And one of the issues that we were arguing involved a contract amendment issue. Now, I thought I had worked out this brilliant argument where I would walk the arbitrators through no less than 6 exhibits in the record to show them how this, there's laughter, how this amendment had been done. Now, if any of you have tried to use 6 exhibits in the record in your oral argument so far, you can probably guess how this went, and you are absolutely right. I hadn't tried this argument before, and I was convinced it was going to be a resounding success. It was not. I absolutely bombed the argument. About halfway through my second exhibit, I could see total confusion on the face of the arbitrators. They were peppering me with questions that I had lost any ability to answer, and instead I just kept throwing out cases that I probably was making up at that point, along with facts that were not true. It was so bad, it was a complete mess, and it was so bad that afterwards, my coaches and my teammates just looked at me with a blank face that I will never forget, and one of them said, well, they can't all be good. So, to come back to it, this is truly a full circle moment for me after getting rejected from the pre-Moot and then coming and absolutely bombing to be here 14 years later and giving the keynote. It's really a nice moment. But moving to my talk now, I did learn from that tremendous failure, as well as more generally from the BIS Moot, an important lesson in oral advocacy and oral presentations. And that's to keep your points simple. And that's what I'll try to do this morning in my comments, thinking about the topic that I wanted to discuss today. And that's what happens when an arbitral tribunal's and an arbitral institution's authority may clash. Now, I obviously chose this topic because it's connected to this year's BIS Moot problem with the issue of who can decide the issue of consolidation. And that's where you have a provision in the clause that gives the authority to the arbitral tribunal, but there's also provision in the rules that grants it to the institution. And I will touch on consolidation a bit. But more generally, I want to think about this issue more broadly in 3 areas. First, why and how a conflict between arbitrators and institutional scope of authority could arise. 2, practically, what may happen when this conflict arises. And third, some insights to consider as how to approach this as counsel. So moving to the first point, considering why or how a conflict between an arbitrator's and an institution's scope of authority could arise. Now, this issue at first blush might seem as a surprising one that can even arise, given the mantra that we all say over and over and again, that the parties' consent is the cornerstone to arbitration. And the corollary that parties are generally free to derogate from arbitral rules that they otherwise may incorporate into their arbitration agreement. If we look at some institutional rules, for example, the ICDR rules in Article 1.1, we can see a good example of where this is enshrined. It provides that the rules will apply when agreed to by the parties, except, and the quote is, subject to modifications that the parties may adopt in writing. So right off the bat, the rules state that they are the default rules that can be modified by the parties. And this is the sort of provision that's common in most modern sets of arbitral rules. As another example, we see these provisions for party modification throughout the rules themselves. For example, in Article 12.1 of the ICDR rules, there's a provision regarding the appointment of the arbitrators that the parties may agree on the procedures to appoint the arbitrator. And only absent that agreement will the ICDR take its default provisions to use a list method. So we start with this provision that parties can modify institutional rules. That's within their right when they agree to arbitration. How then can we end up with issues where parties may have tried to do so and created situations where the arbitrator's authority conflicts with the institutions? Well, there are also limits to what parties can derogate. So for example, in Article 1.2 of the ICDR rules, we see a good example of stating such limits. We have here that the rules govern the arbitration, except that where any such rule is in conflict with any provision of the law applicable to the arbitration from which the parties cannot derogate, that provision shall prevail. So the rules here, as well as in many arbitration laws, do expressly limit the parties' ability to derogate in their arbitration clauses if such derogation will conflict with a mandatory provision of law. Procedurally, such mandatory provisions are often considered as relating to due process principles, things like equal treatment of the parties and a fair opportunity to present one's case. So let's say, for example, the parties derogate from the applicable arbitration rules in their clause to allow one party to present evidence, but not the other. This could be, depending on the jurisdiction, a non-enforceable derogation, as it could impermissibly treat the parties unequally and restrain one party's fair ability to present its case. Now, beyond these basic kind of fundamental due process rights, some arbitral rules also have express provisions that cannot be derogated from, that are unique to themselves. We see here an example from the ICC rules concerning their expedited procedures. In Article 30.1, the provisions provide that application of those rules, the expedited procedures, cannot be derogated from by the parties if they select ICC arbitration. So if you agree to arbitration under the ICC rules, you will be under the expedited provisions, regardless what else is in the clause, if you meet the other thresholds for it. So we do see in different arbitral rules that there are express limitations on the party's ability to derogate from those rules as well. But where the real issue comes up is in what I'll call the gray area, where some provisions of arbitral rules may not be clear if the parties may freely derogate from that specific provision or not. Now, these will include provisions where the arbitral rules may contain mandatory language of what, quote, the institution shall do, or where they provide rules contemplating that only the institution is the entity that is the decision maker for a specific issue. This latter is an example from the consolidation provisions that come up in the Moot this year, obviously. This type of language raises a question of whether parties can contract around the language in the arbitral rules. For example, I have here from Article 14.3 of the ICDR rules. This is a provision regarding the institutions and the procedures for a challenge to an arbitrator. This provision provides that the ICDR, the institution, quote, in its sole discretion shall make the decision on the challenge. Note the mandatory language. Note that there's also no carve out here for agreement of the party otherwise to this effect. Now, given this language, I would say this falls within the gray zone and raises a question as to whether this is a provision that the parties could modify. For example, to allow the tribunal itself to decide challenge issues. Now, I'm not sure if whether this issue has come up under the rules, and maybe we can ask Raphael over a cocktail or at some point later. But it could be the type of language that suggests an additional limitation on the party's ability to derogate from the default rules. Another example we have is Article 34 of the ICC rules concerning the court's scrutiny of an award. As the rule provides, an award cannot be rendered until it is approved by the ICC court. Now, again, I would say the language of this rule falls within the gray zone, but we do know from commentary to the ICC rules that this scrutiny of the award is considered by the institution to be an essential part of ICC arbitration, which the parties cannot derogate from. Now, there's an interesting article by Robert Smith called Mandatory ICC Arbitration Rules, which I'm sure by now all of you have located in your research and preparation. But this article considers when arbitration institutional rules cross over from being default provisions to mandatory rules that parties cannot derogate from. Now, the article is considering the ICC rules specifically, but I think the issues flagged in it have broader application to other rules as well. The article essentially breaks down mandatory rules into two categories. The first is for rules that concern the integrity, quality, or enforceability of the arbitral process and the award. Some issues that fall into this category would obviously be mandatory. As we just saw language earlier, that arbitral rules expressly limit a party's ability to derogate from mandatory provisions of law. The article's second category, which leads more into the gray area, is for rules important to the arbitral institution, but that are not indispensable to the arbitral process. But they may nonetheless enhance the arbitral process's integrity, quality, and enforceability. So example, rules that are designed to promote the efficiency of the process or certain administrative oversights or functions of the institution. So within this second category of potentially mandatory rules in this gray zone, are rules that might be an essential or distinctive feature of the particular institution, or rules necessary for the institution to perform its essential administrative functions, including things at the basic level, like taking the finances, taking the money for the case, or ensuring certain immunity provisions for the arbitrators and the institution itself. ICC's use of terms of reference and scrutiny of the award, which we see here in Article 34, are types of provisions that likely fall within the second category. Now, it's within this gray area where there's the most potential for a conflict between the arbitrator's authority and the institution's authorities, where parties have tried to derogate from the default provisions. One of the reasons for this grayness, however, is that there's a bit of ambiguity as to what the various institutions consider to be mandatory under their own guise. There's not really a lot of transparency in this area. And practically speaking, it might be difficult to get more transparency from the institutions. It would certainly be welcome, but there's often not a one-size-fits-all approach with these issues. The reason for this is that another hallmark that we frequently speak about in international arbitration is the flexibility in the procedure and the abilities of parties to have that flexibility in crafting the procedures both before and during the arbitration that suit their case. And most modern arbitral rules try to respect that flexibility and allow parties to shape their arbitration as much as possible. However, there are obviously limits to such flexibility, and institutions cannot come out and say, this is mandatory, this is not in all cases, perhaps, because they can't anticipate all the creative ways that parties may try to derogate from the default rules. An institution, for example, may allow derogation from a default provision in one case, but may not allow it in another case, the same provision, because the latter attempt to derogate is simply unreasonable. To give an example, many rules have a default provision that arbitrals will be heard by 1 or 3 arbitrators absent other agreement by the parties. Let's say parties try to derogate from this and provide 4 or 5 arbitrators to try the case. Now 5 is already getting to be a lot, and that creates some procedural challenges, but it could be okay, it could work. What, however, if the parties try to say 13 arbitrators should decide the case? This would certainly create a case that's much more expensive, unwieldy. It could take a longer time to work with that many arbitrators' schedules. You might not even be able to find 13 arbitrators that are able to sit in one specific case. Could an institution in that case refuse to allow the latter derogation, but accept the first? But in any case, how would they create a bright line rules to tell the parties whether derogation on a specific provision is too much? And I also mentioned this on the arbitrators because I do know from conversations with ICDR and others that they have had this issue. So it's another issue to ask Raphael, maybe over drinks later, how this was resolved. So with those questions, let's now consider to what practically might happen when there is a potential overlap of authority between the institution and the arbitrators. Now, generally speaking, I think there's three decision makers that can help resolve these issues if they would come up. The first is the institution itself, the second is the tribunal, and the third would be the courts. For the moment, I'll focus on just the institution and the tribunal, but I'll come back to the courts before I wrap up. So looking first at practically what the institutions are likely to do or might do when this issue of conflicting authority between something that they perhaps consider mandatory to them versus derogation of that authority to an arbitral tribunal may come up when we're in this gray zone. I would suggest that as a practical matter, an institution will do one or more of the following things when it sees a clause that potentially creates a conflict between its own authority and the tribunals. One, they would try to resolve the issue with the parties. Two, they potentially could decline to administer the case. Or three, they could refer the issue to the tribunal for decision by the tribunal. And I'll discuss each briefly. But first, before we get into that, when an institution receives a request for arbitration, as if one of the first things the administrators will do is to review the arbitration clause itself and identify whether there are any potential issues with the arbitration clause, including issues like the ones we've been discussing, where the clause may try to impermissibly derogate from the rules. So the first step for the institution, practically, before it does one of these three things I mentioned, will be to identify if there is truly an issue of a potential conflict. If there is, I think in many instances and many institutions are likely to try to resolve the issue with the parties in the first instance. They can do this, for example, by asking for comments from the parties on the issue before any tribunal is appointed and trying to see if the parties are willing to agree to fix the issue if there is one that exists. Now, parties very well may be willing to go along with this approach and to resolve the issues. In this case, you have a situation where the parties want to arbitrate. They have a clause, it's not perfect, but they've clearly manifested an interest in arbitration, and they're already in dispute. And then you have the institution coming to the parties saying, hey, there's something wrong with your clause, or even we can't administer the case like this, it has to be solved. Parties in these cases might be willing to address the issue so that they can preserve the clause and move forward with the dispute. Now, of course, if you have a recalcitrant party who doesn't want to be in dispute and has now changed their mind that they don't want to arbitrate, this could be a very different question. But practically speaking, certain issues with potential derogation problems could and are resolved at the outset of a case, really by the agreement of the parties and facilitated by the institution at a preliminary stage. The second practical option for an institution is if the problem cannot be resolved with the parties, is to simply decline to administer the case. Now, this is obviously a very extreme example, and the institution would likely only do so if it considers that the party's attempt to derogate so fundamentally changes the nature of the proceeding that it can no longer be administered by the institution. Now, the reasoning behind this option is that an institution essentially makes an offer to potential parties to administer an arbitration pursuant to its rules. If the party accepts that offer, but with modifications, here the derogations, with which the institution is not comfortable or did not anticipate, the institution can take the position that it has no obligation to administer the modified case. So even of those of you focusing on the CISG issues, these are now basic contract principles underlying this. It's an offer acceptance and counteroffer, and the institution can reject the counteroffer. So for example, if you have an ICC arbitration clause that says no scrutiny of the award, and the parties refuse to accept any scrutiny, the ICC very well may say, you know what, this is not an ICC arbitration actually, and we will not administer the case. What the parties could do then, they could either proceed as an ad hoc arbitration or go to court to try to resolve the dispute, but this will create its own issues, and it might not be an easier or streamlined answer for the parties. But it's something the parties would have to face if they submit a case that an institution declines to administer. Now, the third option for the institution is just to refer any issues of these potential conflicts between the arbitration agreement and the rules to the tribunal for decision. Now, this is practically what might happen in these sort of conflict issues in many cases, particularly if the issue only arises after the arbitral tribunal has been constituted, as might be the case this year in the VIS. In reality, once the tribunal is constituted, parties are more likely to bring issues directly to the tribunal rather to the institution. But it could also be appropriate for institutions to do so, given the set of rules, given that sets of rules as procedural matters, largely delegate procedural matters to the scope and the discretion of arbitrators. Now, moving on from the institution to consider how the tribunal may practically address such potential conflict issues between their authority and institutions in the case of a derogation. Practically, there are likely two pieces that the tribunal will need to consider to address this issue. First, whether the arbitrators have the actual authority to decide the issue before them. And second, if they do have the authority, what are the substantive factors or elements they should apply to resolve the merits of the issue? With respect to the question of its authority, I'd suggest that the inquiry the tribunal will make is somewhat different than what an arbitral institution would make to examine the question of conflicting authority. A few moments ago, we discussed the institution's inquiry likely will include a question of whether the proposed conflict goes to depriving an essential trait of the institutional arbitration, like scrutiny perhaps in ICC arbitration. But I'd suggest this is not what a tribunal is likely to consider, and also perhaps not what it should consider. Arbitrators have the obligation to decide the issue put before them by the parties. Their authority analysis should be more focused on whether the issue is truly within their scope of authority that the parties delegated to them, rather than on what the essence of the arbitration may be under a particular set of rules. Now, that being said, the question of the scope of a tribunal's authority may circle back to gray areas in the rules. For example, I have another provision of the ICDR rules up here, Article 21 of the ICDR rules, which broadly grants the tribunal authority to conduct the arbitration in any manner it considers appropriate. However, even this broad grant of discretion starts by saying expressly subject to these rules. So even within exercising this broad discretion, arbitrators may find themselves circling back to some of these gray areas in the rules themselves. Beyond this general idea of what the tribunal should consider, there also will be practical issues that the tribunal will need to consider in answering the question of the scope of their authority to examine potential conflict issues. For example, we have in the VIS case, the parties have agreed to allow the arbitrators rather than the institution to make consolidation decisions. So this raises some practical considerations if we actually get to that phase. For example, does the tribunal have authority over the institution to order it to consolidate the cases, where otherwise the institution is doing this? What about cost implications that arise? Does the tribunal need to make some sort of decision there? Does it have the authority? What if arbitrators are appointed in the second case? What authority does the first tribunal have with respect to the first, and vice versa? And what about if there are any issues with conflicts between the arbitration clauses that the tribunal has to navigate? So these questions show that the authority question that a tribunal may have to address implicates questions of authority with respect to other actors or other procedural matters that may not have been clearly delegated to the tribunal itself with the party's original delegation. Now, ultimately, the arbitrator's analysis must be on rendering an enforceable decision that is consistent with the scope of its authority and also with the party's agreement. Because, of course, as you have all studied the Article 5 of the New York Convention intently at this point, an award can be set aside or not enforced under Article 5 of the New York Convention if the proceedings are not consistent with the party's agreement to arbitrate. Now, with respect to the question of the applicable substantive factors or elements to decide the merits of this issue, the default provisions of the arbitral rules may not apply or may not be the right place to look in the case where there is a derogation of authority. In this problem, we have a case where the arbitration agreement not only displaces the entity responsible for making the decision, but also the factors or the elements that should apply in that consolidation issue. Now, I'd suggest that in such a case, The arbitrators need to accept the authority as it has been laid out by the parties and apply the standards in the clause exclusively. The conditions that the parties have subjected their authority to. And here in this problem, for example, that's not the standards in the rules themselves. But even if the arbitration clause does not give an alternative test or alternative standards for the substance of the issue to be considered, the arbitrators may need to look beyond the rules to other applicable law to decide the issues. This is because the rules define how the institution exercises its authority, but that doesn't necessarily define how the arbitrators should or can do so. The arbitrator's authority to decide whatever issue the parties have assigned to it may be subject to different standards or factors on the merits of the issue that arise under the applicable laws. So moving to the third point to consider now, my last comments on the topic, is to leave you with some practical considerations for approaching these issues, both of terms in drafting potentially problematic clauses and also in resolving them if they arise. So first, as the prior comments hopefully elicited, you should consider what the institution is likely to do with the potential conflict of authority that you might be creating or facing in an arbitration agreement where there's a derogation with respect to a gray area of an institutional rule creating conflicting authority. And specifically, the question to consider is, do you have a proper derogation from the default rules, or are you stepping on territory that the institution may consider to be within its exclusive domain? If the latter is the case, then the question is, can the issue be resolved, or is the institution unlikely to administer the case? In other words, are you depriving yourself of an institutional arbitration if that's what you were trying to do with the derogation? Now, beyond looking at what the institution may do as a practical matter, you should also consider the practical impact on enforceability of both the arbitration agreement itself and of the award. Now, this in turn raises the question of, does your derogation render the arbitration agreement pathological such to the extent that it cannot be enforced? So you're not only in a situation where you wouldn't have institutional arbitration, but have you perhaps not agreed to enforceable arbitration at all? Second, it raises the question of, does the derogation create a basis to set aside or not enforce the award? Now, my view on both of these questions is that most derogations will do neither. That is, when we're dealing with derogations that fall within the gray zone of potentially mandatory institutional rules or not, those derogations will seldom create enforceability problems. And I'll close with an example of just one case that I think shows this point. In Anwar v. Fairfield Greenwich, a case from the Southern District of New York in 2010, a group of Chilean investors commenced a number of arbitration claims against their investment firm concerning investments in the Bernie Madoff Ponzi scheme. The investors brought a number of claims in ICDR arbitration, which a tribunal ordered should proceed as one consolidated case by way of a partial award. So it wasn't the final award. And it also resolved a number of other issues on jurisdiction and other things. The investment firm then went to the court in New York to try to restrain enforcement of the tribunal's partial award. The court declined to grant that restraint, however. Specifically, on the question of whether the tribunal had authority to order consolidation, the court noted that questions of consolidation are, quote, procedural. The court recognized that such procedural issues are for the tribunal and that their award could only be vacated under Section 10 of the Federal Arbitration Act if the tribunal had exceeded their mandate in ordering consolidation. The court found no excess of mandate and in fact concluded that the tribunal had authority under the applicable law, which was New York in this case, to order consolidation, and they had exercised that authority within that scope. Because of that, the court therefore declined to enjoin the tribunal's partial award ordering consolidation. Now, I wanted to end on this case because it affirms that most of these issues that we're discussing in the context of what are generally of potential conflicts of authority between the tribunal and an institution concern issues that are generally viewed as procedural matters. And as we discussed a few moments ago, almost all major arbitration laws and rules grant arbitrators broad discretion to decide procedural matters. So particularly in these gray areas of potentially problematic derogations, at least in the question of considering enforceability issues, council should keep an eye to this point. If the clause has a derogation with respect to a procedural issue, delegating that to the tribunal, and the tribunal is also broadly empowered to decide procedural rules, there may not truly be any conflict at all between the tribunals and the institution's authority. So with this point, I'll leave my remarks here and just say good luck in your pleadings and the practice rounds today and in the weeks to come. I encourage you, as I did, to try new arguments, things that may not work, that may fail spectacularly, but take the opportunity of these rounds to do that. If you're going to Hong Kong or Vienna, that's showtime, so take the opportunity to try things and have a bad round. Don't be afraid for that. And I'll say one more thing that I didn't mention earlier, is that even after my spectacular failure here at the ICDR 14 years ago, I went to Vienna with my team and we won a memo prize and advanced the elimination round. So there is hope to always improve and to always learn and get better and take advantage of that. And even if you don't achieve that, you might find yourself invited back to the ICDR one day to make a speech or join the Y&I executive board nonetheless. So thank you for the attention and good luck in your submissions.